have to see the checklist for drafting an effective arbitration agreement is the first question we have to ask, that is the arbitration the best dispute resolution option? It may be that in some kinds of disputes, for example, intellectual property related dispute, you may not want the arbitration agreement, and you may want to go to court. Wherever there is a right in rem and the arbitrability would be an issue, you can definitely consider whether you need to go to arbitration or continue with the court jurisdiction. Multi-step clauses, inclusion of negotiation and mediation prior to the commencement of arbitration. As we discussed, it's always good to have other modes so that you can combine them and use appropriately depending on the dispute arises. Because when you are drafting an arbitration agreement, you don't anticipate what kind of dispute you may get into or when that may arise. So many times we are not having dispute for longest period of time, or sometimes the dispute may arise immediately after entering into the contract. So depending on the nature of the dispute, the amount in dispute, and also on the stage of the contract, performance of the contract, it is always important to give options to the parties to go to arbitration alone, or prior to arbitration, try to resolve the dispute through negotiation or mediation. Which disputes to be arbitrated? In one of the matters we were doing, only the dispute arising out of the termination of the contract where could be arbitrated, and rest all was to be decided by the courts. Sometimes that creates confusion in the parties, because then they are forced to terminate the agreement just to go for arbitration. Whereas the most easy way is to refer each and every dispute arising out of or in connection with the entire contract to arbitration, if the parties are not able to resolve it either through mediation or negotiation. Even for negotiation and mediation, it has to be a time-bound process. Otherwise, many times we have seen that parties invoke negotiation or mediation and then they avoid arbitration on the ground that that is premature. Who will arbitrate and how the tribunal will be selected? Whether you need to have a sole arbitrator or three-member tribunal is something very important, because many times parties come to us saying, yes, just yesterday we got a case where parties have agreed to three-member, but one of the parties thinks that sole would have been better given the time and cost it saves. Also, the appointment process has to be there. So if the parties are not able to agree on a sole arbitrator, then who will appoint the sole arbitrator or the presiding arbitrator in the three-member tribunal? That process has to be provided. The easiest way is to select the institutional rules so that the institution would then appoint the arbitrator, and you don't have to go to court. Because we have seen that in number of cases, if you file Section 11 application, that takes up to more than 6 months to appoint arbitrators. In some cases, it's crossed 1 year also. Although there are time limits provided under the Indian statute, we see that the courts are not following those timelines. Seat and place of arbitrations are used interchangeably in many laws and even the arbitration agreements. The easiest way is to write the seat rather than place or venue, so that there is no ambiguity, because there are a number of judgments which deal with the difference between seat and venue, and we can definitely make out the difference between the seat and venue if we have clearly drafted the arbitration agreement at the inception itself, rather than getting into this debate of what is a seat, what is a venue. It is best to keep it simple and write seat on all drafts which we review or draft. We have to make sure that you clearly write what is a seat and what is a venue. Language of arbitration is very important sometimes when you are dealing with the clients who are not having the English as their first language. In India, we have not seen any problem, but if we are having clients like parties like Japanese, Korean, and Chinese parties, we have to be very careful with invariably, even if they are communicating in English, their internal communication could be in their language, and therefore writing the language for arbitration is very important. Using of arbitration institution is always encouraged. We know the advantages of institution arbitration. You must have gone through this in this series of sessions you have had by now. So arbitral institutions play a very important role, and how to select is also an art. Depending on the seat or the comfort of the parties, we can select the arbitration institution. Choice of law, governing law, we will discuss that in detail, and the currency in which the award will be made. So it's very important is that by the time you get an award, there may be a fluctuation in the exchange rates, and it is always better to specify in which currency the award will be made. If it is to be in US dollars, it's not necessary that if it is made, then in one case, our client got almost 20% extra because the award was made in US dollars, and the Indian rupee had gone down as compared to US dollar by the time the award came. So those are the factors to be kept in mind. Small issues, but very important when it comes to the drafting of the arbitration agreement. Remedies, of course, not compulsory, but it's always good to mention that what remedies the parties will have against the award, and also whether the award will be final and binding on the parties. Despite that, there are limited grounds of challenge in the Section 34 or any other law where the seat if the seat is outside India.